As a Seattle-based attorney who practices throughout the Puget Sound region and has prosecuted and defended a number of sexual assault protection order cases, I have some thoughts about the topic that I think would be helpful to anybody who's considering bringing a sexual assault protection order or needs help defending against accusations. Sexual assault protection orders came into being to fix a problem, and that is not all sexual assaults. In fact, if you read the statistics, most sexual assaults go unreported, and even the ones that get reported don't necessarily get prosecuted. And people who have been sexually assaulted live in a sort of a permanent state of humiliation and degradation and terror when they're forced to continue to interact with the offender or and any accomplices that were involved in a sexual assault. And what sexual assault protection orders are meant to do is to allow a judge to enter an order to protect that victim so that they don't have to live in that state and they can move on, get help, get therapy, and process the event without having the offenders continually in their lives. Sexual assault protection orders require that the behavior be non-consensual sexual contact or penetration, and it can be brought directly by a person, or if there's a minor or vulnerable adult, a sexual protection order can be brought on their behalf. It's important to realize that if you qualify for a domestic violence protection order, you shouldn't file for a sexual assault protection order. The way I see it as a practicing lawyer, and this is a generality, if you had a non-consensual sexual contact or penetration with somebody whom you don't have an intimate relationship with or have not had an intimate relationship with or not dated, then it may qualify for a sexual assault protection order. Sexual assault protection orders are generally filed in the location where the victim is residing, and you can get them on offenders that are out of state as well, though it's a bit complicated and you should talk to an attorney about that. What's good about them is that they enter an order from a judge that says that the offender and any accomplices are not allowed to contact the victim. They're excluded from, or they can be excluded from residences, workplaces, schools, and they can be ordered to keep a certain distance away from somebody. And if the offending party, the offending parties are under 18, and so is the victim, if they go to the same school together, the judge has it within their authority to order them to relocate to another school and pay the costs of doing so. On top of those remedies, the judge is given a wide discretion of power to do anything else that they believe is necessary to protect the victim. And so these are powerful orders, and given the implication of them, they're generally fought vigorously. If you're looking at a sexual assault protection order, we recommend that you read, at minimum, the RCW 7.90, that entire chapter, so you get a feel for what they're about. In defending and prosecuting these, I've seen typically sexually assault protection orders come up when on a first date that involves a lot of alcohol. We have seen sexual assault protection orders surface from teenagers at high schools having inappropriate contact. We have seen sexual assault protection orders come out from one-night stands. And we have seen sexual assault protection orders happen between employees who date. There are an endless number of ways that sexual assault can take place. What's important is if you were assaulted and you do or are living in a state of terror, or humiliation, or degradation from that event, and the victim and their accomplices are still around you, there is a way to make them go away, even if the case doesn't qualify for criminal prosecution. If you're being falsely accused of a sexual assault protection order, these are difficult cases to fight, but they can be won, but it requires carefully going over a story, carefully going over the facts, and weighing the evidence and collecting all evidence that you can to give a whole picture to the judge so that you don't lose in that preponderance of the evidence hearing.